Since the No Surprises Act became law on January 1st of 2022, our firm has received a lot of questions. How do I implement this? To whom do I give it? And what does it mean for my practice? I'm Erin Jackson with Jackson LLP Healthcare Lawyers. The No Surprises Act is aimed at reducing surprise billing for medical services. While much of the news out there has related to how it impacts hospital billing, we've been hearing a lot of questions from small providers. Primarily, these relate to patients who are uninsured or self-pay. Now, self-pay arrangements are common in physical therapy, social work, psychiatry, dermatology. This means a patient pays directly for their services without filing with insurance. Uninsured patients, under this sort of definition, may be patients who have insurance but are paying cash for their services. Or perhaps they're filing for out-of-network coverage because your practice is not in their insurance network. The same rules apply. To these patients, you need to issue a good faith estimate. Now, this is a document that contains your information, the patient's information, and the services that you expect to be rendered to them, as well as the locations where the services will be rendered. In addition to all that, it will include the estimated charges for those services. Now, the good faith estimate will also include an enumeration of certain rights that the patients have. So it's important to point out that the good faith estimate is not a contract. The patient will be informed within the language that they are not obligated to receive all of the services outlined in there. It's simply to give them an idea of what to expect to be charged. HHS has a patient-provider dispute resolution process that they are implementing for this. And so if the actual bill exceeds the estimated bill or the good faith estimate by $400, patients are informed that they do have a right to initiate a dispute resolution process with HHS. These are just a few elements of the good faith estimate that providers and practices should be aware of. There's also a lot of nuance around when you need to provide this to your patients. It relates to when the appointment is scheduled, when the services are delivered, and the amount of time between those two dates. So it's something that's beyond the complexity of this video, but we do have a blog that explains it in a little more detail. If you are seeking assistance in understanding the No Surprises Act and drafting a good faith estimate, appropriate policies, and understanding implementation for your practice, and you're located in any of the states in which our firm practices, feel free to reach out to us. We'd love to help. For more tips on staying compliant, subscribe to our YouTube channel.